Indictment, it's F1, aggravated robbery with a 54-month firearm specification, excuse me, and the attached.
Right away, the charges tell us this isn't a routine robbery case. We're talking about aggravated robbery, firearm specifications, and a repeat violent offender enhancement. In sentencing terms, those extra specifications can add years before the judge even starts considering the underlying crime. Keep an eye on those enhancements. They're going to become a major factor in the final
Repeat
outcome.
violent offender specification to count 1. Also count 9, F3, having weapons while under disability, and the attached 18-month firearm specification. Parties are ready to go forward, Your Honor.
Thank you. Mr. Deeb, any reason not to go forward with sentencing?
No, Your Honor. At this time, we are ready to proceed.
Anything you want to say on behalf of your client?
Let my client address the court, and then I will address the court after. If the court pleases.
Well, Mr. Mason, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes.
Go ahead.
Stand up or
I can
sit
stand up.
Whatever you're comfortable doing. If you're more comfortable sitting, that's fine.
Yeah, my legs kind of.
That's fine then.
I just wanted to say, first off, that I apologize to the victim, and I apologize to my family for just causing so much trouble. Sorry for what I did. Never do it again, and I just hope that I could just, well, not hope, but I know I'm gonna learn from this experience and everything that's going on here. I'm just sorry for everything I did, and I just feel bad for the victim.
This is one of the most important moments in any sentencing hearing, the defendant's allocution. Judges often pay close attention here, not just to what is said, but how it's said. Does the apology sound genuine? Does it show accountability? Let me know in the comments. Do you think this apology feels sincere, or is it simply an attempt to reduce the sentence?
Thank
You good?
I'm good.
Your Honor, some of the things that he left out, and that's why I wanted to, he was concerned about how he would speak in public and his nervousness today. But as I talked about in chambers, he was working at Flow Polymer, and due to the government shutdown, they lost a lot of contracts, and he was laid off, and his unemployment was lacking. He had moved from the west side to the east side to move with his mother. She was going through cancer treatments. He also found out that his daughter had leukemia around that time. He was paying child support up until the point where he lost his job. And this offense happened on November 1st, and he had been unemployed for several months at that point and was behind on everything. And on November 11th, he was arrested, and on the 11th, he was coming back from Cleveland Clinic with the medication he had just purchased with the money from this case. He received $3,000 from his split of the 50-50 split of the proceeds when they were able to get the money out of the safe, and he used $700 of that to keep for himself, which he used for personal uses, drugs, and whatever his expenses were. And most of it he helped with his family, his children, so that they were taken care of. He regrets what he's done. He wasn't forthright initially, but he told the police just about everything in a very quick manner. He assisted in trying to bring his co-defendant to justice, who we learned is in federal prison at this point due to some of his actions, and that was something that was unable to be pursued. There's no justification for what he had done and the emotional cause, but in speaking with him in the jail and asking him what would he have done if something had gone wrong, knowing that the gun was unloaded and they wanted to get out of there and they didn't want to be arrested and they wanted to escape capture at that time, what we think would have happened, then that's when he thinks, I wouldn't have done anything, but at that point he probably would have. I don't think he thought a lot of this through and didn't think, put the time into it. Your Honor, I believe that the time that is going to be his sentence, whether it's the state's recommendation, something different, or the 14 years that we are asking for, this is something that he's going to be taking advantage of, his incarceration, so we can, in our discussions, learn a better way, learn some skills, a CDL, whatever he can learn so that when he gets out, he has manual skills so that he can get a good career type of job with a convicted felon's record, as opposed to just the circle of violence going back again. If something happens in the future, he's going to feel justified in, I need money, so the manner in which I have, even if it's something along these lines, he's shown that he's susceptible to doing that and is influenceable. So I think he's going to take the time to better himself, and 14 years is a significant amount of time to change.
The defense is painting a picture of a man whose life spiraled after job loss, family illness, and financial pressure. Legally, hardship isn't a defense to armed robbery, but it can be a mitigating factor during sentencing. The question is whether the court sees these circumstances as an explanation or merely a backdrop to a deliberate
He's not looking
crime.
forward to that, Your Honor, but he understands exactly why he's doing it. We asked the court to tailor a sentence that would not use any of the time of the RBO spec. Whatever the amount of time, mandatory time under count 1, if the court does feel that more time instead of concurrent, it could be under the 3 years for the weapons under disability, depending on what the court's decision is and whether they go along with either the recommendations or however you tailor that sentence. If for some reason he feels that it would be beneficial to him not to have time, to be serving time for an RBO spec, because that's something he doesn't want on his record, even though...
No, it's on his record.
Well, to plead to it, I mean, as far as to serving the sentence while he's in prison. If the court would tailor it so that that time would not be used. But other than that, we'd ask the court for 14 years.
Thank you. Mr. Shapiro for the State of Ohio.
Thank you, Your Honor. You know, my response to that is, the thing is that the defendant is a repeat violent offender. That's the thing here, is that, and I don't say that lightly. I say that looking at the defendant's history, his juvenile history even, going back to 2009, he has 2 F5 furnishing a firearm to minors. So again, we're talking about firearms at an early age. Then we have 1, 2, 3, 4 separate burglary offenses that occur within the scope of 2 years for which he was committed to ODYS. I don't know how long he went to ODYS. I don't have that in front of me right now, but I can tell you in December of 2015, he was being sentenced on an F4 carrying concealed weapon downtown. He got a year's community control, and just a couple months later, he's back in front of a judge having committed an F2 robbery with a 1-year gun spec while he's on probation for the F4 CCW after having gone to ODYS for 4 burglaries. He got out, he was on post-release control, then there was a post-release control violation in September of 2021 for which he served about 6 months on that PRC violation. Then finally he's off PRC, and there was about 3, maybe 3.5 years where there's nothing on the defendant's record. But he came back with a vengeance on November 1st, 2025 here, Judge. That's our offense. This is a very serious offense. This defendant, he acted in concert with another person. It's a premeditated robbery where they used tools. They used gloves. They used masks to conceal their identity and other evidence. The defendant had a pistol on him that he brandished, scared this victim to death. It was just a man who's in our country trying to do his job, help his family. And while there was no physical harm that the victim suffered, even though that co-defendant did place that sledgehammer on the victim's back when the defendant was laying on the ground to indicate to the victim, don't move.
And here's the prosecution's strongest argument: pattern and history. Notice how the prosecutor isn't focusing only on this robbery. They're building a narrative that this offense fits into a long chain of prior criminal behavior. In sentencing hearings, a defendant's past can sometimes be just as influential as the crime they're being sentenced for today.
Force. Thankfully, no injury there, but scary as hell. And I'll tell you, this victim was not able to sleep for months because of this. Scared to death, Your Honor. Didn't want to know or hear anything about this ever again for the rest of his life. So very serious psychological harm here that the defendant's actions inflicted. He got away also with the safe and $6,000 that he stole from this business. This defendant, and if it wasn't for the solid, hard, as usual, the hard, solid work of the Wycliffe Detective Bureau. They went through, Your Honor saw the police report, unbelievable amount of steps that they took investigating this case, following the defendant. Your Honor, that I met with this man in a proffer, long proffer, it was at least an hour and a half. And he did answer every question that we had. He did it to the best of his ability. And he tried to give us information where we could gather enough evidence to prosecute that co-defendant. And we don't have that at this point. So I will acknowledge that he did do that. But that being said, responding to the repeat violent offender argument Mr. D made, this defendant is a repeat violent offender. So I am recommending on behalf of the state of Ohio a prison term of 18 years, 6 years on the gun specs that have to be served consecutive to each other pursuant to 29-29-14B1G. And then 11 years on top of that on the aggravated robbery, which is the maximum for the aggravated robbery, a precursor that this court has to do to impose repeat violent offender time. And then I would ask for 1 year on the repeat violent offender specification for a total of 18 years, Your Honor. Also pursuant to agreement, the defendant will...
Is any time on the RVO, is that mandatory time if it's imposed? I believe it is.
I believe it is, Judge. I can... Huh?
It is.
It is. I don't have the code section in front of me, that's why I'm stuttering, but my belief is that it is. Part of the agreement is the defendant's going to voluntarily forfeit all the contraband and everything that was seized out of his car. Page 20 of the PSR, there's a list of 36 items that the police took, so that would be what we would want to be forfeited so the police can get rid of those items. And if the firearm's not listed on there, certainly forfeiture of the firearm and the ammunition.
Page 26.
This exchange about mandatory sentencing is easy to miss, but it's incredibly important. Once certain firearm and repeat offender specifications apply, judges often lose much of their flexibility. In other words, some portions of the sentence are effectively predetermined by law. That's why the defense's request for leniency was always facing an uphill
Page 20 I
battle.
have of the pre-sentence report. Yeah. There are 36 items. And then as for credit, the defendant has 210 days of credit, Judge. Thank you.
This court has considered, excuse me, pre-sentence report, an investigation, psychological evaluation. I've considered the facts and circumstances of the offenses involved, the nature of the offenses involved. I've considered everything that's been said here today by Mr. Deeb, the defendant, prosecutor. I received a letter from the defendant a couple weeks ago, not even. I received it just 4 days ago. I think he wrote it about a week ago. Read that, considered that. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For all the factors in 29-29-12, the court finds factors indicating the conduct is more serious is that the defendant acted as a part of organized criminal activity. This was planned out with other individuals and carried out with other individuals. The victim suffered serious psychological harm, and he still does, as a result of the conduct. No factors indicate it's less serious. As for recidivism factors, court finds the defendant has a lengthy history of juvenile delinquency adjudications, as well as convictions as an adult. And the convictions are serious convictions. You know, we get lengthy records here often. So a lot of times they're misdemeanor offenses, minor drug offenses, or even felony drug offenses, but possession charges. But with the defendant as a juvenile, there's 3 burglary convictions and 1 attempted burglary conviction, or adjudication, I should say, in which he was committed to the Department of Youth Services. Then as an adult, got prior conviction, felony conviction for a weapons charge. Then he committed a robbery with a firearm specification. Sent to prison, served time, put on parole, violated when he was on parole, and was returned back to prison. So he has failed to comply with previously imposed sanctions ordered by courts. He didn't get released from prison until April 15th of 2023, and then a year and a half later, he commits this violent robbery. Those are factors indicating recidivism is more likely. Nothing makes it less likely. Due to the defendant having a prior felony in the first degree, as well as the fact that there's firearm specifications, there's a mandatory prison term required to be imposed. Prison's consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions.
Here it comes, the moment everyone in the courtroom has been waiting for. Listen carefully to the judge's reasoning. Sentencing isn't just about punishment. Courts must explain why the sentence fits both the crime and the offender. Based on everything we've heard so far, what do you think is coming? Something closer to the defense's 14-year request, or the prosecution's push for 18 years?
Therefore, it will be the sentence of this court that on count 1, the defendant serve an indefinite term, a mandatory indefinite term in prison of a minimum of 11 years, maximum of 16 and a half years. That shall be preceded by 54 months term for the mandatory term for the firearm specification, plus a 1-year mandatory term for the repeat violent offender specification. The court specifically finds that prison term imposed is inadequate to punish the offender and protect the public from future crime because the applicable factors under 2929.12 indicate a greater likelihood of recidivism, indicating a greater likelihood of recidivism outweigh the factors indicating less likely. I mean, there's no comparison there. Further, the court finds that the factors, the prison term imposed would be demeaning to the seriousness of the offense because the factors indicating his conduct is more serious than normal outweigh factors indicating it's less serious. I mean, this is what you think about when you think about a robbery, an aggravated robbery, but that's not what we typically deal with. Typically deal with robbery charges. Someone pushes someone as they're shoplifting out the store, or someone pushes someone and takes something from them. This is the robbery where someone approaches, and when someone was the defendant, approaches the victim by himself at night, the gun pointing at him, telling him to give me your money. And that's what you see in the movies. This is the worst form of the offense. And the defendant did this before. He's committed a robbery with a gun before. And a year and a half after he gets out of prison, he does it again. So the court finds, based on what I stated, that the additional 1-year term is appropriate for the repeat violent offender specification because you are a repeat violent offender. You don't want that on your record. You don't want to be considered that. Well, then you shouldn't have done it. But you did. Pursuant to statute, all those sentences are consecutive to each other. In count 9, the court will sentence the defendant to 24 months. I will run that concurrent with the prison term imposed in count 1. Defendant is further ordered to serve an 18-month mandatory prison sentence to be served prior to and consecutive to the prison term. The firearm specifications are to be served consecutive to each other for 6 years total. Those are to be served prior to and consecutive. Those are to be served prior to and consecutive to the indefinite term imposed of 11 to 16 and a half years for an overall mandatory prison term, the whole term is mandatory, of 18 to 23 and a half years in prison. There's credit for 210 days. You'll be given that credit. And in order to defendant to pay restitution in the amount of $6,000. I need to advise you that upon your release, you'll be placed on post-release control for at least 2 years, up to possibly 5 years. While in post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term imposed, any additional prison term imposed. For violating post-release controls being imposed as part of the sentence at this time. I'll order the forfeiture of the contraband that was seized and agreed to be forfeited. I'll dismiss the balance of the indictment. I'm further going to find, even though I don't think it's necessary because consecutive sentences are by statute mandatory. Everything I imposed in terms of the consecutive nature was mandatory. But I further do find that they are necessary to protect the public from future crime and to punish the offender. They are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. I believe that covers everything. Mr. DePiro, is there anything else?
No, thank you, Your Honor.
Mr. Deeb, anything else for the record?
No, Your Honor.